Welcome to another episode of Legal for Tech, the podcast. So, guys, you do recognize my voice. It's always Rosie here. And as I've said many times, this is just a group of students and young professionals who are very interested in anything that has to do with technology. And yes, it's regulation. So, I am joined today by a friend of mine and the actual producer of this podcast. Hello, Giacomo. Great to see you.
Hi, Rosie. Thank you. And to the first episode recorded in 2026. This is the first one.
Yay. We made it to 2026 and we almost made it to 100. So like it's all on you. Like I'm just gonna point that out. Well, and we are joined today for a very special episode because as you can hear from my voice, I'm told that my voice goes up when I'm very excited. I'm super excited because we are joined by a friend of the podcast, Mateusz Kupiec. Hello, Mateusz.
Hello, Rosie. Hello, Giacomo. Thank you for having me here and Happy New Year both to you and the listeners.
Happy New Year to you. And this is a very important year because, as we know, a lot of things are under revision, reconstruction, and Mateusz is an expert of the GDPR. So, what we are doing today to start the year with a flair that we have never given before, actually, we are writing the New Year resolution of the GDPR. So, it's amazing to have you here, Mateusz, because as I said, it's incredible that we can actually do this together today on recording. Thank you for joining us and accepting this incredible format.
Thank you for having me here. I think that we'll have a wonderful discussion and conversation about the privacy.
Very much looking forward to it. But before we start, I guess our listeners will want to know why you're an expert in the GDPR, why you're here, and really what led you to study this specific topic.
Okay, so a few words about me. I work at Traple Konarski Podrecki Partners, which is one of the leading law firms in Poland that deals with data protection and digital regulation. I also act as an external data protection officer for organizations in the energy and biopharmaceutical sectors, so highly regulated sectors. I advise clients on maintaining the maturity of their privacy programs, provide advices regarding GDPR compliance, but also compliance with AI Act, DSA, and other EU digital law. Apart from being a legal practitioner, I am also a researcher at the Institute of Law Studies of the Polish Academy of Sciences, where I am writing my PhD dissertation on children as data subjects under EU data law. So, as you can see, I live with one foot in practice, so in the real world, and one foot in the ivory tower of academia. And I find it incredibly valuable because these two worlds constantly correct each other. Why did I end up in this particular field of work? Well, sometimes when I get up, I ask that question myself before, the round of the calls with the colleagues and clients. To be honest, I don't want to sound too cliche, but I've always been fascinated by the relationship between the new technology, information, and power. As a teenager, I read a lot of dystopian novels, Brave New World, Neuromancer, of course, Fahrenheit 451. And those books convinced me that technology and the progress is never neutral. It structures our choices, our autonomy, our relationships with others. And law is one of the few tools left that can still push back or at least shape to some extent the developments.
Usually, the 1st of January is the day when you think about the new resolutions for the year. So, for this episode, since it's the first one recorded in 2026, we want to do to change a little bit our format, and we want to do that with you because you are an expert in the GDPR application. So, could you give us what you think should be the GDPR 2026 New Year's resolution? Could you give us uh, we would say five for time management purposes? Let's start with the first one if you
Okay,
already know it.
the first one would be the most important one, would be follow the CGU. If I had to formulate the first resolution for this year, it would be follow the courts of justice rulings more closely. Not just the LinkedIn posts that hit very fast after the judgment is published, or just skipping through the press releases. Not only fragments quoted in somebody's blogs or LinkedIn posts, not even my summaries that are displayed on LinkedIn, but really follow the whole reasoning just to cut through the hype. Because the reasoning behind the court's judgments really have a real impact on GDPR implementation and enforcement practice. For instance, 2025 was ample with many important judgments. Russ Media case, for instance, is the latest one from December, with also another judgments like EDPS versus Single Resolution Board, and that judgment has shaped, or maybe the judgment will shape, because we are not sure what their real impact will be, but they are very likely to shape the whole GDPR practice.
I really appreciate you saying that because I have to say, like, I work for a law firm and I'm already citing Russ Media, and it's a month ago, and I'm already writing legal opinions, writing down Russ Media. It's been huge, considering that in less than a month it's changing literally how lawyers are advising companies to do things. So 100%, I'm standing with you on that. Um, how how do you think that this resolution could be kind of put into force if we want to use the legal jargon? Because I'm thinking, for example, LinkedIn, I mean, you can't just have a verifier. Would you have more verifiers on LinkedIn, or would you say that, for example, the decisions of the European Court of Justice should be recorded, like in some other jurisdictions? How would you solve this issue?
I would go with the recordings. I saw that after Rus Media case, there was a lot of noise regarding that judgment, and people were not sure what was the real reasoning. Some people, they have problem with distinguishing between the Advocate General and the CGU. And I think that in this new year, one should work on their privacy literacy, but in terms of understanding how the European institutions that create and interpret European law actually work. For instance, we have a European Data Protection Board. Yes, that is the body that is comprised of the representatives of national DPAs. And a lot of legal practitioners do not do not know actually how the EDP works. They only know about the guidelines, but they often cannot distinguish whether the given guidance has been adopted or has been adopted for public consultation. Okay, so what I mean is that in the new year, one should read more carefully regarding DPA's decisions, CGU judgments, and also EDP recommendations or guidances. One shouldn't follow just the noise, just the LinkedIn hype, but try to read the judgment, the documents, and have their own opinion.
So let's say that resolution one for the GDPR of 2026 is to have better practitioners, literally, which which I think is a legit point to make, especially when everyone is like, oh yeah, the GDPR is not applied carefully, it's too strong. Well, maybe if it were applied correctly, maybe we wouldn't think it doesn't make sense or it needs fixing. Who knows?
Yeah, I
I
agree.
leave I leave that hanging. Um, And let's go to resolution number 2. Which one should it be?
Well, follow the discussion on the digital omnibus. And digital omnibus, the proposal is often discussed through slogans like rollback, deregulation, end of GDPR, end of the world, even the apocalypse. None of it really helps, and it misses the point. The real stories behind the omnibus is much more interesting. So for me, the omnibus proposal does two things at once. Firstly, it aims to simplify and clean part of the regulatory system, which is frankly necessary because, the GDPR has been applicable since almost 8 years now. The waters of the GDPR interpretation is murky. Sometimes people cannot follow, cannot understand all the requirements, or the requirements tend to be formulated too vaguely. And then we have an omnibus proposal that is necessary for simplifying the EU digital law. But when it comes to omnibus, what really interests me is the shifting of power toward the European Commission. When you read the omnibus, the provisions of omnibus, you can see that the Commission aims to give itself new powers to issue new implementing acts, such as, for instance, criteria for when pseudonymized data become non-identifiable, cannot be identified. They are not personal data anymore. And, it is tantamount to regulatory centralization in the Commission, because there are several risks. Firstly, political pressure, and also the annulment before the CGO, because as we know, the life expectancy of the EU implementing acts regarding data privacy law, we have, the transfer decisions to the USA, for instance, the life expectancy can be rather short. And when such implementing acts are annulled by the CGO following, for instance, the complaint from the human rights organization, the effect is extung. So it means that for instance, the whole data processing operation that was deemed lawful under the European Commission, following the European Commission implementing acts, will no longer be deemed compatible with GDPR.
So let's say that the second resolution is that GDPR becomes simple in being applied, but not simply dependent on something. It's more
Yes.
like,
So follow omnibus discussion closely. Don't panic. Don't cheer. Watch carefully. I would formulate it in such a way.
well, that sounds like a slogan that could work for the whole of 2026, since
Thank
we
you.
had a great start, basically. Follow carefully, don't panic, but also don't cheer too much, right?
Mhm.
And what should be the third resolution for you?
AI Act. So AI Act and new compliance reality. So we have the next layer to EU digital law compliance is AI Act, and of course some of its parts have already been applicable since 2025, like the provisions related to prohibited practices, such as, I don't know, in emotion inference in the educational institutions, or rules for general purpose AI. AI literacy obligations, and the big wave arrives this year, because since August this year, the Act becomes fully applicable, and this includes also the obligations for high-risk systems, for instance, human oversight, or the fulfilling requests for related to explanation in individual decision making, for instance, under Article 86 of the AI Act. And I see from my practice, it seems that many organizations are still in denial. For instance, they think that they will deal with this when somebody tells us that our system is a high risk, or whether our machine system is an AI system itself. But for me, it's a really wrong approach because privacy programs have to be ready for AI Act and AI Act compliance. Many organizations implement automation, and in many instances, that automation is related to to deploying AI systems. And therefore, companies should map AI systems already in use, identify potential high-risk roles and users, understand their role under the AI Act, whether they are the provider or deployer, because it also has impact on their role under the GDPR. So so I think that that would be my third resolution for this year.
So the solution for this year should be that the GDPR and the AI Act kind of work together, because potentially compliance with the GDPR when it comes and automated systems can be facilitated by complying with the AI Act. I would also say, if we think of something like Article 22 of the GDPR, I mean, it could be easy to comply with Article 22 to ensure that you have a system of compliance also with the AI Act. So I think companies and organizations need to think about the possibility of using the AI Act in terms of a weapon rather than and a shield as well, rather than simply saying, okay, it's hurting me and I don't know how to do this. Actually, it can be helpful.
Yes, I couldn't agree with you more. Sometimes, AI has changed. AI is changing the landscape, and more and people are concerned about the AI use. And even us professionals do not always comprehend the exact impact of the AI system on the functioning of the society, the risks for the rights and freedoms, because uh, well, because sometimes AI systems work as black boxes, and their effects, their results, are not always comprehensible for us humans. So
And
it's not.
exactly, and I feel like also hardly tangible. Like it's difficult to see the causality between you potentially not getting a loan and the AI system behind it. You probably don't know how the bank works. I've talked to a lot of people actually, also from like younger generations in a way, that are still convinced that maybe at the bank there's some kind of guy that reads the documents and tells you like likes you or doesn't like you. And I'm try to explain that, I mean, many of these systems are automated and there's a lot of prior automation to the point that this guy is receiving a module, for example, that has not been, how can I say, made through by a human person. It has been still elaborated through an AI system. So what they read potentially is not really the situation, but it's something that has been um, generated through an AI system. And I think people don't understand that. They don't understand where the AI system is. They don't understand the impact. They see a person at the bank and they think, okay, it's them. No, not really. And that's an impact that we need to consider, I think.
Yes, I think that we need to consider that people who operate AI systems, for instance, in the bank, bank officers, bank clerks, that, for instance, use AI systems to assess one's credit worthiness, they have to work on the AI literacy, and the companies that deploy AI systems to streamline their workload, to improve the quality of their services, and so on. They have to also understand and do not forget the fact that still some of that AI systems will be operated, will interact with humans, even with their clients or the users or with their own employees, and their employees have to understand how that systems operate and what are the risks of using them for the clients, for the peoples affected by the results generated by the AI system.
After discussing after the half of them, what did you place a number for?
Number 4, I would say do not wait for the DPA to knock on your doors and update your privacy documentation or GDPR related documentation. From my practice, sometimes organizations they wait for the letter from the DPA before they start taking privacy more, GDPR compliance more seriously. And I think that maintaining mature privacy program and good GDPR documentation requires ongoing work and ongoing updates because organizations are like a living organism. It's changing. So the structure is changing. There are new systems being added, for instance, AI systems or some kind of automation tools. And all the changes sometimes may lead to uh, the necessity of updating for instance, registry of privacy activities or of registry of privacy activities or mapping or other documents, other relevant documents.
I feel like this is the resolution that would correspond to I will go more to the gym this year. Like, it's the one that you tell people, like, maybe you should go to the gym a bit more, take care of your, body and stuff. And they're all like, yes, yes, yes. They all subscribe to the gym in January. And then by mid-February, they will not go. And I feel like this is exactly what happens into organizations. You start off with the idea, okay, we don't have to wait for the DPA letter. We will do all of our compliance straight from the beginning. We will have all the documents spot on point. And then after a couple of weeks,
Yes, there is.
"Oh, maybe I don't need to." It's,
Yes, I think that the core message should be updating documentation is not housekeeping. The meaning of the documentation may change it, and it's not merely a housekeeping exercise, but it's the real necessity to know how the privacy program to make the privacy program in the organization work actually.
it's a huge point. So let's say if we want to sum it up, in order to make GDPR better, make sure that you follow the process throughout and you document it rather than just acting as remembering that you have to comply with the GDPR just when a danger or a potentially kind of challenging situation comes, because the GDPR is not the type of regulation that you just comply with in times of need. It's a practice, it's not an emergency. So I think it's a great point to make, especially after talking about the AI Act. So it's a great placement for that number 4. And endly, at the end of this great conversation, what is number 5?
The 5 would be get real buy-in from your organization and people that you work with. For instance, I don't mean not formal approval or polite nodding in the meetings when you are that data privacy pro who mentions GDPR and AI Act compliance. But real buy-in, I mean, under that term, I mean, that management and your peers accept ownership of the privacy risk and the management is willing to prioritize privacy and AI governance, not only product development. And in most organizations I work, in most organizations, the biggest problem is not the absence of policies. The problem consists in the awareness related to privacy program and that privacy and AI governance is still sadly seen as merely a legal project, not as not as a core element of strategy and risk management in the organization. So I think that such a genuine buy-in would look like that the DPO getting a real buy-in from the organization requires the data privacy professional to have a real unhindered access to senior leadership. It's really important for DPOs, especially it's also a legal requirement under GDPR. And it means that uh, the senior management has to understand the role of data privacy professionals, of data protection officers, uh, and treat them like the real task.
Looking back at these resolutions that you said, is there a reason why you chose disorder? For example, you pick disorder in terms of importance, or are the five resolutions equally necessary?
So for me, all the resolutions are equally necessary, but I think that I start with the easiest one is following CGU closely. So I structured it because of the let's say difficulty stage, I think. Because following CGO judgments or mapping your organizations regarding AI Act compliance is much easier than getting genuine buy-in from senior leadership or updating your uh, documentation related to privacy and AI governance. Because, well, when you update the documents or get the buy-in from the organization, you have to work with others. And there are a lot of, dependencies and some intricacies when you work in the organization. You have to follow the rules, the management structure, and so on. And following CGU judgments more closely, it only requires your discipline.
Um, I was struck by one thing that we are talking about the resolution, so like the things that need to change in a document, which is the GDPR, that's been technically very much, let's say, controversial, especially in the past year because of the United States, potentially the pressure upon the decision-making bodies of the European Union in terms of like achieving more growth, achieving more development, more technological innovation, and everything that came with it. And we saw that in the digital omnibus, which is the great closure of this year of controversies and of doubts in the GDPR. And I really appreciated that basically all of your points are regarding the people and the organizations that comply with the GDPR. Because sometimes it's easy to look at a problem and take the most tangible expression of that problem, so the text of the GDPR, and maybe it could be a bit more analytical and a bit fairer to the text and to the rights of the people that are protected in the text, to look at how it gets implemented, because at the end of the day, it's people that make the GDPR, whether they are data subjects, controllers, joint controllers, processors, or whatever. It's the people that make it. So I really liked your analysis in reminding us that amongst the frenzy and the doubts and the shaming, I would say it's a document shaming operation, the one that's going on with the
Yes,
GDPR.
yes, the question when we discuss digital omnibus, and the changes in the European digital law, data law, the real debate is not are you for or against GDPR, or are you in or against data privacy or fundamental rights. The real debate is who should interpret fundamental rights in the digital societies, independent regulators or courts. And how do we build a system that is both workable and legitimate? So we shouldn't avoid both extremes. We shouldn't panic and declare the end of the world because of the omnibus package. And we shouldn't panic every time when we see the word simplification in the legislative proposal. But we shouldn't also, treat the omnibus as a benign housekeeping, because it will be fun, it will be important because the final version of the omnibus, so the final regulation, the final wording of that regulation piece will constitute how we protect our digital privacy.
Wow.
So
A great
vigilance
message.
without hysteria.
I love your slogans. I feel like someone is going to use these slogans. This is going to
Yeah,
be
I really
the.
hope so. So I really hope so. Vigilance without hysteria it sounds really good. As I mentioned, today is public holiday in Poland, so I had a lot of time to think about some slogans I would like to share because of it, our new resolution team.
I have to be honest, the vigilance without hysteria, I think is going to be one of the things that I'm going to tell my mother very soon. So it kind of applies everywhere. The European law is our mother in ways. Anyways, thank you so much for this conversation, Mateusz. It was a pleasure and an honor to listen to your ideas, and really, really, it made me think. And I hope that our listeners will do the same after this conversation.
Thank you, Giacomo. Thank you, Rosalia, for all your questions and for having me here. Have a wonderful week ahead of you.
Thank you. You too.
Thank you.
Thank you. This was all for Legal for Tech, the podcast.
This episode was brought to you in partnership with DG Beetle. DG Beetle helps privacy professionals to stay up to date with the most important European documents in the AI, data and digital space every day. Curious to know more? Check out the link in our show notes.